no, don't worry about it, I think that would bring me to bullet number 3 under reporting. If the report involves the superintendent, the employee shall report his or her suspicions to the board president.
Well, I don't think it ever involved the superintendent, and I don't think anything in the report indicated from the grand jury that it involved the superintendent.
You're saying that the superintendent told him that it was board policy.
But that's the way the board chose to handle it.
That's the way it had been operated since 2005
right.
or 6.
So I understand that this is the way things have always gone here, but maybe if the person had followed the policy and when they hit a roadblock had gone to the next potential place that they could blow the whistle, we wouldn't be sitting here with an attorney general investigation and a wide embarrassment to our district.
Perhaps we can all be Monday morning quarterbacks, but the policy says the investigation, once that report goes to the superintendent, falls on the superintendent.
Wouldn't that reset, say with a new superintendent, there were 2?
You're imposing a responsibility on him that the policy doesn't impose, and you want to punish him for it. Now, look, maybe there was a different policy when this was passed. I don't know the date. When was this passed? June the 1st of 2015. So it probably, the action predates the policy date. Maybe there was a different policy, and we ought to look at that. Because maybe it's different. Maybe it's very different. Okay, we're talking about a policy that wasn't in existence at the time that conversation occurred.
Okay, so then if the policy started in 2015, then that person should have come forward with this potential fraud at the time to that superintendent.
I'm sorry, I can't hear you, and I don't mean to talk over you. So you can finish, and then I'll answer. And I'm having some trouble hearing you, so I apologize.
No, I mean, if that would be a perfect case in point, then if the policy, let's say it didn't exist until 2015, then with that new policy, then it would be incumbent upon that administrator to come forward again with this information that there's potential fraud going on in the district.
Perhaps, but even if they did that, or if this policy was, in fact, in effect at that time, the responsibility then, once it's reported to, and it wasn't this superintendent, let me be clear on that, okay? Once it was reported to that superintendent at that time, according to this policy, the duty to investigate that shifts to the superintendent. It's clear. It's clear as the nose on my face.
But the superintendent...
You're imposing a duty on him that's not his responsibility.
The superintendent wouldn't have... The superintendent that started in 2014 wouldn't be aware of it, potentially, and then...
Well, we need to know what the policy was then. So we're looking at a policy that really predates the action, and we're trying to punish him based on this policy that first of all, in my opinion, because I looked at it, the responsibility to investigate that rested with the superintendent under this 2015 policy. This action occurred probably prior to 2015, so we have to look at what the policy was then.
But these were ongoing. We have a document that shows that the actions were going on for however
And even if that superintendent went to the board and the board said, that is how we choose to operate, then what would you expect?
I would, if it were me, I would go to the authorities.
As I did?
We're not
As
talking.
I did, Ms. Cognetti?
You did in regards to
excellent work.
You said you went to the authorities. You said you went to the Auditor General, but on what?
Now wait,
Based on what?
if this is a personnel hearing on me,
I'm just asking.
I
You said it twice.
insist
I
on
don't know what
being
you're...
represented by my attorney, and
Just
it
asking
would
a
be
question.
held in closed session, period. You're not going to go on a witch hunt with me.
I'm not. You said it twice. Does it pertain to this? I just want to be clear. You said you heard it, you saw it or something, and you went to the...
I saw something that I felt was inappropriate.
So it's not this. It's not
I
this.
brought it to the Attorney
I heard
General,
that piece.
the Auditor General's attention. The Auditor General looked into it, and sure enough, in the report says that that was not fraudulent activity. What I asked them to look into.
Okay, so I just want to get back to the budget piece. So, Mr. Schuster asked how involved our department heads in their budget, and they are. So,
And how many times am I going to sit here and be humiliated in front of people in the audience? If you have a problem with me, you speak to me as a member of this board in private, in executive session.
Can I speak now? I allowed you to speak. My question was directed to Mr.
Barely. You allowed me.
Okay, getting back to my question. So, if they're involved in their budget process, okay, you know, taking aside everything else we heard, but, you know, if my budget, or I'm overcharged 800 grand or close to that, I think I would see that, or I'd have a problem with that.
How do
over the
you
course
know
of a couple
you're
years.
overcharged that much?
Well, it's still coming, but it's coming out of your,
You saw the bill lists every month. Mr. Schuster, as board chair, worked directly with Mr. Sunday.
I asked
Did
Mr.
you
I was
see
asking-
anything odd going
my
on?
question was posed to
I
Mr.
don't
Lapp.
see any of these bills, so I wouldn't know.
You see the bill list
'Cause they're approved.
every month.
Let me just,
All of you.
me-
You see
I
the
asked
bill
Mr.
list.
Lapp
let me just, Mr. Cantor, if I could just point out one thing, and I'm trying to lower the temperature just a little bit. One of the things.
We aren't going to lower it with me tonight because I feel like I'm being ambushed unfairly in public, and this will be documented as inappropriate behavior on this board's part,
As I,
of which I'm the 10th member, by the way.
as I read the grand jury report, I did notice that the business that was directed to the vendor went down considerably over the course of a 4 or 5 year period, from I think a high when the COO or whatever started of like $100 and some thousand a year to the last year of about $29,000. So obviously he was taking business away. He wasn't happy with the service he was getting. So, you know, the budget impact became less and less each year. But it's a gross number. That person never saw the bills, Mark. He never saw the
It's just
bills.
a problem.
It does, or what?
Pardon?
That's why I asked the question. And got
It's a legitimate
screamed
question.
at.
It's-
Asking the
So
question.
I think some of the
It's a member of
Well,
responsibilities.
you could scream at me silently, or I can scream at you loudly. I know what's going on here. I was not born yesterday, for God's sake.
So I think this does fall under, what you're getting at is it does fall under the responsibilities of the department heads. That, what was the policy? It was just read a few minutes ago.
828.
828.
And I think at this point in time, we're looking to follow policy and take some kind of action, and looking for action from you. I know we discussed due process the other night.
Well,
and
there's
you
due
as legal
process,
counsel.
but also involved in due process is Section 828, and I read it. I did. I looked at it, okay? A report went from that individual to the former superintendent. Under that policy, it falls on that superintendent to investigate that. That wasn't done.
And that
You- you- you-
superintendent
you want-
was
you-
Mr. King.
You want to, you know, take action against this employee, but it appears to me, from what I can see based on existing policy, that he followed it. But this is the reason that I asked for independent counsel, okay, because it involves personalities. I would much prefer, and I asked for this, I would much prefer an independent, non-affiliated with the school district set of eyes to look at this, to make this decision and recommendation to the board as a whole.
We can't
I think-
afford it. Sorry.
Pardon me? And, you know, and I think that, you know, that might be the best thing that you as a board could do. But that's your decision, but I did ask for that, okay, and that was the reason. So I'm sort of being asked to look at these things as a hybrid in between. I'm really not comfortable doing it, okay? I'm trying to look at it and call balls and strikes, all right? And sometimes if I call a ball or a strike, somebody doesn't like it, you know, I'm sorry. That's how I see it, okay? That's how I read it. I could be wrong. You should get a fresh set of eyes to look at it. That's why I asked for that. I think that's fair to me, and that's fair to you.
And you have an RFP that I had done within 3 days presented to you. I'm not stalling on taking action at all.
I mean, you're either going to pay me to do it or someone else. You're still going to pay to have that work done. And, you know, odds are, there's bids pending on legal counsel. I didn't bid to remain here as legal counsel. I've enjoyed my service and working with you, but it's time for me to do something else. And, you know, you're going to have a general counsel, you're going to have a labor counsel, and you're going to have a special ed counsel. I don't think We all know who that's going to be yet at this point. And you want to get someone that's going to finish this, from start to finish. So that's my recommendation. If I'm told to do it, I will do it, and I'll carry it through to that point. I'll try to call balls and strikes as best I can. But, that's my recommendation. And I'd really appreciate that. And I think that'd be good for us so that we could avoid this kind of discourse.
Ambush?
And could I please say something following that on a calmer tone? I think all of us want to make the right decision and make it as quickly as possible. There's no question about it. But it is a trepidatious time. None of us have been in this position before, as active as these things are. And I just would like to err on the side of caution, as well as moving as quickly as we could to make the right decisions. I think we all want that. I don't think anyone doubts that. But at this point, I don't feel very comfortable up here with some of the questions that are being asked and some of the motions are being made. And that said, with all due respect to every single director up here trying to get the questions answered they want so they can make the best decision. I do understand that as well. That being said, I think there's a lot of other places that this can be done, and we can continue to move forward as quickly as possible. I feel the same way. I think that the rest of the board feels when I'm saying we want to move quickly, but we want to move properly. That's all. Thank you.
And I support that, Paul, and I released a statement saying so. I just don't believe that this is the right time to act. The investigation is ongoing. When people are charged, that's when I believe people should be taken action against.
I read it. I read every word of it, and I tend to agree with a whole bunch of it, and that's why I said what I'm saying right now, and I just want to make sure that we all move forward as quickly as we could, but we make the right decision. And we don't want anyone working here that's done something wrong. I know that, but we have to make sure of it, we have to make certain of it, and we have to see what our legal move should be very quickly. And I agree with what Mr. Menorah said when he said we should definitely take this into legal hands. None of us are lawyers, but we are tasked with trying to make the right decision, and that's difficult.
I also think employees, they have due process rights. They have rights to privacy. We're sort of trampling on that right now, and I think this is a discussion that we can have. It shouldn't be had in public.
It's executive session.
It shouldn't be had, and we're violating those employees' rights right now by doing that, and coming very close to, if not trampling on those rights and exposing the district. And I want to be on record as saying we need to stop doing it. And if we don't, at least I said it.
In regards to that, I see when we're hiring an outside attorney, it is taxpayer money, so I do see it as being part of the
I understand it.
When in the last, so I've been on the board for 3 years, and over the course of 3 years, we've had a couple different disciplinaries. How did they all kind of worked out pretty much the same, similar actions were taken? Can you just give me a rundown of how those actions were taken and where we went?
Generally, you do a pre-Loudermill, okay, and once you get the pre-Loudermill, unless the recommendation is dismissal, you're not going to get a full Loudermill hearing, which is for professional employees, not for non-professional employees. So with the pre-Loudermill for your non-professional employees, you can enter into and take some disciplinary action, but you need a full set of facts, and you need some type of board policy that's violated. So, those are the things that we need to look at, okay? And we need to, identify who we're talking about here, because in some instances we're not completely sure. We have a good idea, but we're not completely sure. And then, you have to remember that there are allegations in a report, and that's just what they are, allegations. And when you ask an employee, if those allegations are true, and they say no, where do you go from there if we don't have any further evidence? Which is the point about which maybe waiting for additional evidence might be prudent, or not. I understand where you're coming from, and I understand your anxiousness, and you're getting a lot of pressure from the public. I get that. I do get that. I'm not trying to poo-poo what you're doing. I know you're coming from the spot of trying to do the right thing. I just want to make sure that we don't trample on those rights. And, I need some direction too. I made a recommendation, right? And honestly, I don't really have an answer one way or the other yet from the board on which direction you want to go in. Do you want, private counsel? If so, there's an RFP prepared. That seemed to be the direction we were heading. If you want to change that direction and go a different way, we can. It's not what I would prefer or recommend, but if you tell me to do it, I'll do it. I work for you folks and the superintendent, okay?
We've saw a couple past actions where before Loudermill was done, the employees have been suspended.
They've been suspended, sometimes with pay, sometimes without pay, but in those cases, it was clear. It was clear prior to a full Loudermill. There's usually
on video, for God's sake.
Usually there was a pre-Loudermill before that occurred. There'd usually be a meeting. There was almost always a pre-Loudermill. I can't remember an instant where we did it without meeting with them, Doctor. Can you?
No.
No, there was
But
always
were
a
those for
pre-Loudermill.
union employees versus,
Pardon me?
with those for union employees? whereas
And there was
it
always a pre-Loudermill meeting. There was always a
For members of unions, correct?
Pardon me?
For members of unions, there would be a Loudermill.
Everybody has due
Everybody has
process rights.
Loudermill rights.
Everyone has Loudermill.
Yeah, professional employees like teachers and administrators that are certificated have an additional full Loudermill hearing in front of the board, okay? And the non-professional employees, pre-Loudermill.
And that's exactly why you need counsel to direct you.
And sometimes even with the Loudermill rights, under the collective bargaining agreement, there's a grievance procedure that they can opt into. And, so we've had situations where employees have been disciplined and they've gone to grievance route. We just had one not that long ago, if you think about it. So there's different ways that they can go as well, which impacts things also, if they're union employees. It's frustrating because the process gives public sector employees a lot of rights that they wouldn't have in the private sector, where they're at-will employees. In the private sector, you can get rid of somebody just because you feel like it, if they're an at-will employee, if they're not protected by a union. Here they are, and they have rights, and we have to respect those due process rights.
I think a key point to just keep in mind is that we don't have to wait for criminal charges to look into this, something that keeps...
I didn't say that. I
Not
didn't-
you, but others have, in the last
I
couple of
didn't-
weeks, keep saying that we're waiting for the Attorney General to charge people. And again, like anything, any other employee, something that would happen internally or in any private business, you don't wait for a criminal charge to discipline an employee.
Certainly in a private business. I mean, Pennsylvania is an at-will state, so if you're an at-will employee, you have no rights if you don't belong to a union or you're part of a collective bargaining agreement. Here, you've got Loudermill rights, and if you're in the union, you've got additional rights under your collective bargaining agreement. You might have a right to a grievance. And if you're a professional employee, on top of the pre-Loudermill, you have the full Loudermill hearing right. So we know that, okay? We know what those due process rights are. I'm not suggesting to you that we have to wait for somebody to be charged in order to take action for discipline.
Right, you have not said that, but others
If I
have
made that
suggestion,
I did so incorrectly.
No, you did not. Others have
Okay.
implied that in the last couple of weeks.
But I do think that we have to be careful. And one of the things we always want to avoid, I call it ready, fire, aim. Let's just make sure that we're heading in the right direction, that we have the right game plan here. Let's, give your administrative staff some direction. If you want me to do it, fine, I'll do it. If you don't want me to do it, and you want someone else to do it, as I suggested, you can do that too. Either way, there's a cost, Mr. Schuster. I understand, your respect for taxpayers' right, but there's going to be a cost, right? Whether I do it or someone else does. So I'll do it. Excuse me. Whatever I'm directed to do, okay? And I'll finish as much of it as I can, before my term here ends. But I want to do it the right way, and I want to respect employee rights, and I really don't think that we're doing that tonight. And I think we should be careful of that. They have those rights. I don't want to end up in a federal civil rights lawsuit because we're violating those rights and those rights to privacy right here. So that's my 2 cents on it. I'll do whatever the board directs me to do. You folks can, discuss it and make a decision on Monday night, and we can proceed.
I think we should wait until we have, and this out of respect for you and what you said, I think we should wait for our new counsel to make a decision in terms of hiring legal counsel. We are about to change all of that. I think we should see what they recommend, because what I don't want to do is hire a very expensive investigative law firm on top of what we're already.
I'm sorry.
Sorry.
I'm just having trouble hearing you. I
She
hear
wants to wait for the new council to come in. I believe that's what you said, to help you all make a decision. Is that correct?
Right, I don't want to hire an investigative law firm on top of what we're already about to hire up to 3 different legal firms coming up, so
That's
I don't
fine,
wanna add a
and
fourth.
you'll have continuity then, which
Yeah.
is important.
Right.
And I think it's something I pointed out
Right,
last week.
right.
Do we have dates on interviews?
You are going to look at March 29th for the presentations? I'm sorry, October 29th, for the work session, for them to do their presentations for you. And then after that, in between that date and the board meeting, you are going to hold your interviews. And then at the November board meeting, you are going to select and vote on those who you wanted to offer employment to.
So nothing gets done till in November.
It's up to you.
Nothing really gets done till November with new council. Because we have to interview them or have them present at the end of October. Is that what I heard, or is that my take?
Is there an earlier date
Well,
available?
don't you have to bring this to the full board and have
I'm
a
just
discussion?
asking a
This is
question again
committee
that I'm not
meeting.
allowed to do. Every time I do, I asked a question. So we're not going to get any legal counsel on any of this until November.
Unless you decide to put the RFP out, speed up the RFP, and bring somebody in before then.
I don't think we need to bring someone in before, because then we'll
Okay.
because that process is going to
Then
take a long time.
that's what you're going to, I believe, bring to the whole board.
Or we forego the presentations because we had people bid, we have their bids, and we just vote sooner than that.
Well, I still don't think, I think the reason that it was put off for so long is because multiple attorneys that applied are going to be not only out of state, but out of the country, that won't be able to, am I incorrect by saying that?
I think October 13th is the return of all of the groups.
So could we have them present to us in a special session earlier than the 29th? That would, to speed that up, so potentially we could have them in place sooner than that?
We would have to contact them and see if they're available, and what we're believing is all of those that have been presented to you in the chart that was a color-coded chart are those people who you would like to interview. So we will present that back to you with the names to make sure that's who you want us to contact for them to make presentations to you. Do you all remember the chart you were given?
We do also have another evening scheduled for committee meetings, correct?
You have committee meetings scheduled October 3rd. That is our policy employment meeting.
Right.
Then on the third Thursday of the month, you have an additional policy meeting for other policies. You have an education committee meeting.
Is it the third?
I'm sorry, October
Thursday or
3rd?
third Monday?
I believe it's the third Thursday. I'll have to look at my calendar. Maybe the third Monday. I'll check for you.
Be wrong
The
as well.
15th.
That's what I,
What do you have?
the 15th.
So perhaps we can have those presentations on the 15th instead of the 29th.
Instead of the committee meetings?
You would need to make that a special meeting if you were going to vote.
I mean, we wouldn't want to vote the same night, but potentially we could hold a special meeting
29th.
before, we could hold a special meeting on the 29th to get it at least started a week early.
Virginia,
Yes.
I don't see this date on my calendar. Do you remember if it
October
was
15th is the third
the
third Monday.
The 15th?
Yes, that would be.
So what do you want to happen on that day?
If we can get the presentations from the attorneys that have put in for the RFQ.
And what time would you like to start?
6 o'clock.
I'm not comfortable with any of this until we speak to the whole board, president, vice president.
I'll make this tentative. Virginia,
Yes,
we can get maybe an email out tomorrow
sure.
and first contact Mrs. Dixon, find out if that works for everyone. And I really agree with Paul that this needs to be a broader discussion. The plan to interview, the plan for presentations, the plan for interview, the chart you've been given, I think you're going down the right path with all of that. Right now, what's critical on your minds is what you're going to do with some employees. And I really believe, and I've said it a million times tonight, you need legal counsel. I've been through several grand jury investigations. The biggest mistake you can make is to try to proceed without legal counsel. You need it.
And I don't think any of us are trying to change the system and the chart, and I think we're just hoping we can bump it up 2 weeks to speed this along.
Bump up the presentations and the interviews,
Yes,
sure.
I mean, I think
yeah,
that's-
but we
If it
would
doesn't work, okay,
reach out
but
to the
it's
rest of the
possible.
board.
Right.
Anything else? On to the next
You
agenda.
could thank me for putting together your framework anytime you feel like it. I would
Thank you.
appreciate that. You're welcome.
The next agenda item is grievances, so an update on our grievances, where they're at, what we have left, what's.
Well, Ms. Boland and I have met with Bill Gaynard and Matt Loftus this last week, and we went over all of the past grievances that we had. There were several that may go to arbitration, but we have talked about bringing them to the board and seeing if you all would like to make a different consideration before they go to arbitration. We're now, I believe, into the year 2018, and we will be working forward with the grievances there. I don't feel comfortable talking about individual grievances because many of them involve employees and should be discussed in the proper forum.
I can tell you that there's a pending grievance with the clerical union that I confirmed this evening. We have a pending ULP with the SFT, okay? And there were several grievances that were filed just recently. I think Doctor was referring to that may or may not go to arbitration, or they may end up before the board, at board level. Hopefully that saves everyone money. There were two that were finalized, and one that needs to, one grievance that was, we agreed to submit on briefs, and we just have to set the dates up to submit those on briefs. And then the second grievance, there's another one that was finalized that involved a payment that may not have occurred yet. So I need to talk to Mr. Gaynard and Laffey about that. That's generally it.
Do we have anything that needs to be scheduled for a hearing, or anything that's at the board?
Not at this point. Not at this point. And even if you did, given the fact that you're going through a change, I would probably suggest you wait.
Anything else?
Like a motion to adjourn?
I'll take a motion to adjourn.
Second that.
Stand for the Pledge of Allegiance. I pledge
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you very much, and thanks for Westside for hosting us here tonight, even with the cancellation of the meeting. The first item on the agenda is the single tax office contract. So just if there's an overview of that, or any changes from last contract.
Well, the basic overview is that although they'll be paid a bonus, the bonus will be paid by the city and not by the school district. So we've got no increase in wage. the city to absorb half the salary of one employee that we had been paying a full salary for, which resulted in a savings of about 20 or 25,000, Mr. Laffey, roughly. There was a slight change in health insurance to the benefit of the employees in the single tax office, but that cost was minimal, like $12 to $15, $20 a month, something like that increase. Yeah. Okay, and then the final piece was there was an increase in accumulated sick and vacation time. Is that correct, Mr. Laffey?
It was sick leave, the cap on sick leave was increased
So overall, the feeling after Mr. Laffey and I reviewed it was that the contract would result in a net savings to the district, probably in the range of $18,000 to $20,000 per year.
Yeah, the $20,000, which was actually greater than half healthcare and full fees, would be something that we realized. The increase on the sick payout would only be observed upon retirement or upon the exit of employees. So that's hard to determine what that number weighs is, $1,522.50. And there was also the social security death benefit, like went from $7,500 to $10,000,
Right.
which is a very material amount out of pocket for the district. That it's a $2,500 increase on that, and if we pay 25 cents per $1,000.
That's what I was talking about.
So the bonus payment is in exchange essentially for no wage increase?
I'm sorry.
The bonus payment is basically in exchange for no wage increase, is that?
That was correct, and the city absorbed the bonus cost.
Right. But in looks like Article 23 says, beginning October 31st, all parties will reopen discussion of wage increase.
I'm sorry, I can't.
Article 23,
Article
did you say?
23 says that there will be no base wage increase for 2018 annually for the duration of this agreement, beginning on or before October 31st, 2018. All parties to this agreement will reopen the discussion of wage increase.
There's a wage reopener if and only if our financial circumstances change. But that begins a new negotiation, and I think that's after 2 years.
Okay, so if our financial circumstances change, is that us and the city or the school district?
I'm sorry, I'm having great difficulty hearing you.
Sorry, I'm talking into the microphone.
That's
I'm going
the
to...
acoustic.
It's hard to hear.
The financial circumstances changing, is that the city or the district, city and the district? How does that?
It's largely the district.
Okay.
It's largely the district.
Okay.
I just have a statement on this. My wife has been employed with the tax office since 2007, and my sister-in-law has been employed with the tax office since 1990 somewhere. So I won't be voting on this. I'll reiterate that at the meeting.
So, Mr. Menorah, what about, I know this isn't about the changes to CBA, but the e-collect issue was something that the single tax office was wanting to work out based on their CBA. So do we have any update on that?
No, we don't, and we don't. It wasn't going to be an impediment to resolving the contract. Mm-hmm. So we moved forward with the contract, and we'll probably continue and may end up in grievance arbitration on it if we can't resolve it.
About e-collect?
Pardon me? Yes.
About e-collect. Okay, so on that, this is more of a reiterated statement and not a question, but if you see on page 4.3 of the contract exactly why I had called a couple of weeks ago for one of the law firms that applied to be labor counsel to be eliminated from contention. You see here that there are signatures for the solicitor for the Scranton School District and a separate signature waiting for the, quote, labor counsel, City of Scranton. in the future, the solicitor piece would say Labor Council, School District of Scranton, and the fact that the firm that applied didn't disclose that they are eCollect's legal representation continues to give me a lot of heartburn over that particular application. So I would just still reiterate that I think that firm should be disqualified, and I can't see how we move forward with them.
Well, this isn't, yeah. Well, you know, again, you can raise that issue at a voting meeting, and Mr. Moran can answer that, or his firm. I can't answer for them.
Oh, no, I mean, it's a statement, not a question. I just wanted to point out that in reading this signature page is precisely why it's a problem, that they did not disclose something we all know to be true and something that is a very clear conflict of interest. So I just don't think that conversation should be over.
Any other questions?
No.
Was there anything else, Mr. Monroe?
Pardon me?
Was there anything else, Mr. Monroe?
No.
All right, moving on to agenda item number 2, the framework for the Attorney General investigation and school district response or action plan.
I have an updated version for you, a revised, due to some actions that have been taken up to this point and some feedback from the board members.
Oops, sorry, here you go.
Thank you. Ms. Orr.
Oh, thank you.
Did everyone get a copy?
Yes.
So, Mr. Schuster?
Yes.
Would you like me to give you a little update?
Yeah.
All right.
All right, so Dr. Kirian's going to give an update and a rundown of the Scranton School District Grand Jury Response Framework and her action plan. You still can't hear that?
Is it better that we just talk without the microphones? Because when we're up here, I can't hear a thing when someone talks into the microphone.
So it's better without the microphone.
Okay.
All right, so a review of the framework that is being proposed has been revised due to some actions that have been taken to this point. So I'll start in the left-hand corner, and you'll see everything that has a check next to it are things that have been initiated up to this point. The second column, where we talk about initiate, let me go back to the first column. The second check from the bottom is originally said recommend to board hire of independent legal counsel, or addition now is assigned to solicitor or labor counsel as you see fit. The second column talks about how the process of approaching this would be initiated, and once it is handed over to the board's choice of legal counsel, then you would want the legal counsel to review with you due process rights, relevant board policies, and administrative procedures, and then develop strategies and translate those into action plans to proceed with the investigation. And in that, we had discussed a communication strategy, and the recommendation was that the legal counsel incorporate the communication strategy into the RFP proposal if you choose to go out independently. And then appoint a district spokesperson to avoid confusion or mixed messages, and to determine and track the cost to the district on such an investigation. And then the implementation would be, as the grand jury hands down charges, then to look into those internally and decide how you will proceed, and follow the protocols set in your action plan, implement your communication plan, and call board meetings to vote on any recommendations that are recommended to you regarding personnel. And then continue to monitor the AG's findings, because in the presentment that we received, it was indicated that more investigating will be done, and we're going to have to try to follow that. I believe a question asked of me earlier when this first came out was, what information does the district have? And I wanted everyone to be perfectly clear that the only information I have found was the report online, same as everyone else. I did call the AG's office to try to get more information. I did not receive a call back. And I also contacted PDE to let them know what was happening. And the advice that I was given was to proceed cautiously because of due process rights. Then we talk about the follow-through, so the board, with the help of council, would need to continue to monitor the progress. We would adjust our strategy and actions as necessary based on the roadmap provided by the Attorney General's office, ensure that our checks and balances are implemented, and update any policies and/or procedures as recommended by legal counsel regarding this matter. And then finally, to assess, we would continue to monitor the findings and repeat strategies laid out by counsel as necessary. So there are quite a few of actions that were taken in the left-hand side, and the RFP has been developed. It has been shared with the board, if that's the direction you choose to go.
I have a question. Okay, so you said the items in the left-hand side that are checked off are already completed, correct?
Yes.
Well then, okay, the 1, 2, 3. So number 3, identify employees. So have you done that?
What I have done was to take the initials of the employees that have been mentioned in the report and tried to match them with employees that we have. None of the employees have been charged, and so I'm reluctant to call names of employees because they really are only identified in the report as initials. And that is one of the reasons I called the Attorney General's office to try to get more information on these initials. Are they indeed employees that we may assume they are? And if they are they charged with anything? Because those charges did not come down at this point.
Okay, so at this point in time, I do like what I'm hearing, where we're recommending the board to either hire independent legal counsel or assign to our solicitor. I think at this point in time, spending taxpayer money on, a private investigation or an internal investigation, I don't think is needed at this time, but we do have that RFQ out there. So if we need to do that in the future, we can go towards that. I do think the investigation has been pretty much covered at this point in time, and I think we're I'd like to see us go is, we do have some district policies regarding fraud, and we have policies regarding discipline actions, things like that.
And I reviewed with our solicitor and made some notes about our district policy, as one of the board members had contacted me regarding specific policies. So if you'd like, I'll review my notes with you, but I would suggest that even though I would review these with you, that these should not be considered final word, that you should get this information directly from the person who you choose to conduct the investigation. So the first policy that was brought to my attention was policy 317, and that is conduct and disciplinary procedures. So as this policy was reviewed, an employee, well, first of all, the policy is effective. If you recall, we did a lot of policy work starting with my arrival. So this policy kicked in September 13, 2016. So would not have been in effect at the time of 14. Nonetheless,
Kieran, may I ask, was
Yes.
there no policy at that time, or is this an amendment to the policy
this is
that
an
existed?
updated policy per PSBA recommendations. So for 317, what we looked at was a paragraph that was brought to my attention about one of our employees, and the employee is mentioned in the report as having shared with but not testified what particulars happened when that particular employee questioned the process that was being used. And accordingly, the employee at the time did the correct thing and was told by the superintendent at the time that this was not that particular employee's responsibility, that it was board policy at the time, and I don't think any of us were around at that time, to operate in a certain way. So based on that, that employee met his or her responsibility by reporting to the superintendent at the time. And the superintendent indicated that they were directed by the board, that the board chose to operate this way, and that was the policy at the time that they were following. So
Can I just say something?
Wait.
Does this have something to do with the ongoing investigation right now? Plausibly?
Plausibly, yeah.
Here's what I would say. I'm not comfortable sitting here listening to or talking about anything that has anything to do with an ongoing investigation right now. I understand that we want to set up a structure as to how to move forward as the investigation moves forward, but I don't want to get into the legalities and the what-ifs and the hearsay that goes along with anything that's going on right now. So it makes me very uncomfortable. I don't think we should be doing it whatsoever at all, period.
The one thing I'm going to say is that we are talking about an active employee. So
I agree. So as
it
things
has-
come out, we have to move exactly along with the investigation.
And understand that although no employee's been named here, employees have privacy rights and due process rights, and this is something that's better discussed in executive session those privacy rights are the employee's rights, not ours to waive. And we might, just be crossing a line here, so I would suggest that we save this better for executive session. Obviously, if some type of serious discipline has to happen, the board eventually has to vote on that in public, excuse me. But there's a reason that employees' privacy rights and discipline and so on are protected, and they're confidential, to the point that they're not even discoverable under a right to know request. They're absolutely barred.
So I'm holding in my hand a public document released by the Attorney General. It's a grand jury report.
I'm sorry, I can't hear you.
It's a grand jury report released to the public. I was sent it by a member of the media before I even heard it on the news myself. This is a very public document that publicly names certain individuals and gives us the...
What names?
Well, we
Jeff
can't
Brazil
say
is
names.
named in this, and Mr. Joe Slack is named in this.
Okay.
They're current employees. I find it hard to believe that there were no policies in place before 2016 that governed wrongful conduct.
So that's where I was going with that one. This policy was adopted June 16th of 14, but again, it's hard, there would have had to have been conduct and disciplinary procedures.
But even if that were the case, if June 16 of 14, you look at the pages here where people got work done and it got charged to the taxpayers, that happened, one of these instances, for example, that we're talking about right here, September 22nd, 2014. A lot of the other dates are 2015, 2016, 2017. So this policy was absolutely in place, and current employees that are in our district, I believe, given the policies, I think that we have the right to request that there be discipline.
Well, first of all, we should not be calling names in public. None of us
This is a public
should.
document with their names in that.
Yeah,
I don't know what else you want me to do.
But we don't know who has seen the document.
Everyone in town has seen the document. The entire city has seen this document. The Attorney General released it publicly for a reason.
Well, if I may, based on what we know at this time, it is inappropriate to take action. Maybe at a later date, it will be appropriate to take action. I really can't support on what we know at this point that there is a violation of policy 317 or 317.1. I'm not suggesting that went on at the time was right or wrong. None of us were here. All we can base our conversation on is that this is an ongoing investigation. The person mentioned did follow procedure. The superintendent at the time pretty much said that's board policy. So if...
Board policy meaning what? Please explain the board policy piece to me. That a board said to this superintendent, you better let this guy do whatever he wants with these bills. That's how it's coming off to me.
No.
Well,
that's
what was identified. And you know what? You've suspended people for stealing 2 rolls of toilet paper and wanted them terminated. You've suspended people.
I haven't. The board has.
Well, you brought it to us in that fashion.
I recommended suspension.
You recommended that.
Based on that.
And
yes,
here,
I
some
did.
of this stuff, the investigation has been concluded by the highest legal authority in the state.
I didn't think the investigation was concluded.
But information has been brought forth. Okay, it is ongoing, I get that, but stuff has been identified along the way. And the reason it's ongoing is because, you know, I guess there's more to come. But I don't feel comfortable waiting for this framework. I mean, I looked at it, I agree with parts of it, but this could take months. And unlike you, I'm a taxpayer that lives here and pays taxes.
No, that
it's not a shot,
totally
but you know what?
Unnecessary.
Well, I'm just saying that,
my family
you know what?
lives here and they pay
And I'm an elected
taxes.
official, and they come to, you know, people come to me and say, Mark, we can't spend any more money. They're saying the same thing that I feel, that this investigation, part of it's done, okay, is it ongoing, but stuff has been identified that we need to act immediately and not wait for another investigation.
Well, that's the mistake of many boards that I have seen in the past. When you fly by the seat of the pants and you don't take legal advice. I'm not a lawyer. I'm asking you to get a lawyer to give you legal advice so you can proceed properly.
So at this point in time,
We can suspend
what
and do
we're,
due process and then have legal opinions on this. We've done it since I'm here. I just feel like that this is going to take too long, and I question why.
so I'm basing everything that I'm seeing on the words of this individual at the grand jury. So
Read the first word of of that part, would you, Mr. Schuster?
the title is criminal conspiracy, and the first word is COO.
And what did the COO do?
He was informed of this agreement by his predecessor and the former superintendent, and based upon those instructions, he did not question the validity of the arrangement. So he was in office or in his position from 2011 until recently. And I don't know, is Mr. Laffey still here? When we do department budgets, how much is the department head involved with their department budget? When we're doing the budget, the yearly budget, how much is the department head involved in the budget process of that department? So, I mean, if we're aware of this, sorry, but I mean, go ahead.
Salary guidance are typically prepared by the central office, usually the business office. Anything from, supplies or if it's education-related textbook materials are, done with the assistance of the department head or the supervisor.
Yeah. So, I mean, from what I'm seeing as an active employee was aware of this special agreement. It may have been brought somewhere, but it didn't go to the policy states it goes to the superintendent. If the superintendent's involved, it goes to the board president. So at that point in time, did he go to the superintendent, and when it wasn't resolved, he went to the board president to take action?
I don't know, because the report doesn't tell us that.
Yeah, so now,
It also
but it does say
uses the
his
word
words.
advised. It does not use the word testify. So we don't even know if this person testified in front of the grand jury. Does anyone know that? I don't know that. Does anybody know that? He advised. He didn't testify.
So did he bring this to your attention when you took over as superintendent?
No, because Mr. COO was still in charge. When I went to the COO and asked for things, I was told, the board has advised me. You were on the board, Mark. You were on the board. Many of you who are sitting here
And who did I
tonight were
advise?
on the board. And I was told, I was advised by the board that this is my responsibility, and I am to do this. So,
I think at this point in time, we're looking to advise for some disciplinary actions
for what?
for being aware of a conspiracy to defraud the district.
Who's aware?
Right, so it's policy 828, fraud, delegation of responsibility. District administrators are responsible to be alert to an indication of fraud, financial impropriety, or irregularity within their areas of responsibility. The superintendent shall recommend to the board for its approval completion of a forensic audit when it is deemed necessary and beneficial to the district. All employees should be alert for any indication of fraud, financial impropriety, or irregularity within their area of responsibility. An employee who suspects fraud, impropriety.
As the superintendent,
Thank you
I
for
was
interrupting me. I appreciate that.
marginalized. I was pushed to the side. The board, including the budget chair at the time, worked directly with the COO, and I was left out of discussions. I was left out of decision-making and everything else.
So wouldn't it follow, though, that administrators like Mr. Brazil and you as superintendent had an obligation to suspect that something was wrong and to report that?
I had no reason to suspect something was wrong. In fact, Ms. Cognetti, long before you arrived, I had heard of something that was not what I thought was right in the district, and I brought it to the Auditor General. The Auditor General began to look in it and discovered some other things.
Right, so
So-
wouldn't it have been helpful if Mr. Brazil had followed the policy 828 and alerted you to potential fraud, financial impropriety, as he was aware of it since 2011?
You're talking about policy 828,
Right,
is that
and
correct?
That's the policy that we discussed. And
As
think-
I said, I am not a lawyer, and I strongly recommend that you get a lawyer to interpret this for you. I see clearly this evening that you want to place blame and you want to take action immediately. It's obvious what you are doing, and I will tell you, you're going down the wrong track here. Superintendents prior to me, from 2001 forward, uncovered none of this. The Auditor General came and did several investigations in our district and uncovered none of this. None of it. When I suspected something was wrong, I brought it to the Auditor General.
If Mr. Brazil had failed in 2011, it seems like, to get Mr.
He did, but she's not hearing that.
This is a public document. I don't know, it's a public document with statements from the Attorney General.
But I think she said that Mr. Brazil brought the matter to the superintendent.
Right.
Followed the chain of command the way he's supposed to.
Right, he did
And
it once.
I think the last conversation that you and I had about this, Mr. Minori, you were going to
And I did
review
look at it, and
828.
if you look at the rest of that policy, once it's brought to the superintendent, then it's to the superintendent to act from there. So when that was brought to a former superintendent's attention, and he said, no, that's board policy, it transferred the responsibility to investigate it to the superintendent. If I have the policy, I could read that, because I did see that. It was either 816 or 828.
It's 828.
Well, let's get back to the budget question.
So here it is.
Okay.
The superintendent, investigation. The superintendent shall investigate reports of fraudulent activities in manners that protect the confidentiality of all parties and the facts in cooperation with the appropriate individuals and agencies. And before that, it says, employees who bring forth a legitimate concern or suspicion about impropriety shall not be retaliated against. So the investigation responsibility at that point was no longer his.
But my interpretation of this, and I think if I were in this position and I did bring this to a superintendent who told me